So political courts controlled by right-wing MAGA justices are continuing their assault on American democracy. Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So I've got two stories from the news today about the continuing efforts of the MAGA Republicans to take control of democracy no matter what the voters say. One of them comes from our Supreme Court, which of course has had a banner year this year, making it harder for the EPA to stop climate change, overruling Roe v. Wade, and forcing all taxpayers to subsidize the Christian religion. That's on top of decisions assailing the Voting Rights Act and cutting the legs out from under unions and employees. But the Supreme Court has signaled that they're just getting started. Today they announced that they're going to hear a case from North Carolina, testing what's sometimes called the independent state legislature doctrine. Now, there are a couple of points to unpack here. The first one is that part of the way that the Supreme Court sets its agenda is by what cases it decides it's going to hear. You see, each year, over 10,000 cases are submitted to the Supreme Court asking for it to make a ruling. And each year, the Supreme Court only hears about 100 of them, granting what's called certiorari, or as lawyers call it, granting cert. And to do so requires the agreement of 4 justices. Not a majority, but enough to show that they think that there's a legitimate issue that needs to be discussed here. Well, in this case, the Supreme Court has granted cert to a case from North Carolina, brought by the North Carolina Republican Party, in response to action by the state Supreme Court. Now, you have to remember, North Carolina is definitely a swing state, with a Democratic governor and Democrats controlling the state Supreme Court, but which was narrowly won by Donald Trump in the last election, and of course, as a result of gerrymandering, has an overwhelmingly Republican state legislature, but that's a whole other story. And what happened is, the overwhelmingly Republican state legislature decided that they were going to gerrymander themselves a very nice map, granting Republicans 10 of the 14 congressional districts allocated to North Carolina. Well, Democrats took that case to court, and the state Supreme Court held that the legislature's action went against the state constitution. Now, you have to remember, under our system, state courts are the final arbiters of what the state constitution says. And so they sent this map back to the legislature, saying that they had to come up with a fairer map that actually complied with the laws. Well, that's the ruling then that was appealed by the Republicans and taken to the U.S. Supreme Court. And generally, state court issues aren't resolved by the U.S. Supreme Court because, again, it's the province of the state Supreme Courts to resolve these issues. But the argument here is that this is a congressional election, a federal election. And the appeal is based on language in the Elections Clause of the U.S. Constitution that says that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Now, that language has generally been interpreted to mean that the states are the ones who determine how the senators and representatives are going to be elected, not the federal government. And the language here is consistent with a lot of language throughout the Constitution. In fact, repeatedly, when the Constitution places limits on the ability of the federal government to do something, they don't say the federal government shall not do something. They say Congress shall not do something, or Congress shall be required to do something, or such and such a power shall be granted to Congress. And that never means, by the way, that Congress can do whatever it wants. It just means that this power is vested in the federal government, not the state government. Well, similarly, this clause makes it clear that the process of electing the federal representatives is something that falls to the state governments. And that position has been reaffirmed time and again ever since the founding of our republic, most recently in 2019, when the Chief Justice, John Roberts, wrote in Rucho versus Common Cause that, quote, provisions in state statutes and state constitutions can provide standards and guidance for state courts to apply when addressing gerrymandering in federal elections. And similarly, in 2015, the court held that, quote, nothing in that clause instructs nor has this court ever held that a state legislature may prescribe regulations on the time, place, and manner of holding federal elections in defiance of provisions of the state's constitution. That was an Arizona State Legislature versus Arizona Independent Redistricting Commission. But as we know, this current Supreme Court grants absolutely no deference to precedent and what everybody has considered settled law for hundreds of years, right? So who knows what they're going to do here? You see, the argument of Republicans is that where the elections clause says the state legislature, that means that the state legislature can do whatever it wants, that the state courts can't step in, that the state constitutions have no bearing on what the state legislatures are going to do, that the executive office can't intervene, and that the voters can't set up things like independent elections commissions. No, according to Republicans, their gerrymandered state legislatures can do whatever the hell they want. And that's what Justices Thomas, Alito, and Gorsuch seemed to indicate earlier this year. So now that Amy Coney Barrett's on the court, who knows what's going to happen? Just one more step, apparently, in destroying American democracy unless we do something about it in this upcoming election. But as it turns out, all the action isn't at the federal level. In Wisconsin, which has been referred to as Hungary on the Lakes, for the level of authoritarianism and anti-democratic behavior that their Republican Party engages in, the state Supreme Court there just handed down a decision by 4-3 margin that the state Senate can stop the Democratic governor from appointing people to help run the state. And to make matters worse, by refusing to approve the people appointed by the Democratic governor, the people who are appointed by the Republican governor get to stay in office. In other words, it doesn't matter that the voters voted for a Democratic administration to run the state. If the gerrymandered Republican state Senate decides they want to keep the Republican office holders in place, again, despite what the voters say, they can do that simply by refusing to consider the appointments that the governor makes. Just one more dagger in the heart of democracy. So anybody who claims that this is just politics, spare me. This is a concerted, across-the-board effort by the Republican Party to destroy American democracy. It's nothing short of American fascism. And if we don't stand up to do something about it in this next election, it just might be too late to save democracy. Well, if you want to hear more about the lengths to which the Republican Party has gone to turn the Supreme Court into a right-wing junta, just check out this video I did over here, where I talk about revelations that came out a little while ago about the extent to which the FBI engaged in a cover-up to make sure that Brett Kavanaugh was appointed to the U.S. Supreme Court. I'll see you then. In the meantime, let's hope for continued progress. Thank you.